All rise. Court of Appeals Division 1 is now in session.
You may be seated. Good morning.
Good morning.
We're here today on our case number 1, CV150846, EPPERSON versus AAA Fire and Casualty Insurance Company. Counsel, as you both know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use for rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of your own time because the clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve.
Yes,
we record these proceedings, so when you approach the podium, we'd be grateful to you if you would recite your name and the name of your client. We have reviewed, we've studied the briefs, reviewed the record. We've also discussed the case in our conference. So with that, Mr. Watkins, you can proceed.
thank you.
I will reserve 5 minutes. My name is Joe Watkins. I'm here on behalf of Norma and Ron Epperson, the plaintiffs in the underlying case. This case was brought to me as a fire loss insurance bad faith claim. I was approached by the Eppersons approximately 3 months after the date of loss. They were being pursued by an investigator from AAA. My first meeting with the Eppersons indicated to me a couple of different things. Mr. Epperson was quite confused and very incapable, in my opinion, of being an accurate reporter of information. Mrs. Epperson was not nearly as involved in the process as Mr. Epperson had been, and they were seeking help. They were frightened. They were worried. They felt like they were being, in their words, treated like criminals. The first thing I did after they retained me, and they did retain me because they did not have the ability to pay attorney's fees, we put them on a standard contingent fee contract. Historically, I've done over 100 of these claims in the past, including Mount Lemmon claims, Chetasky claims, many of these claims. I started making phone calls. I immediately got a hold of the fire chief, Jim Borrego, who had been the responsible party at the scene. I talked to the chief. He indicated to me that he had not been contacted by anyone from AAA or anywhere else, and we discussed the claim, and he did not think there was anything that he could point to that was suspicious. There were reports that it could have been suspicious because it was a big fire, destroyed the property, so I thought I'd go right to the source. The next thing I did was contact neighbors and the individual who had been with my client the night of the fire. They had been spending the night there. They'd been doing repairs. Again, this individual had not been contacted by AAA. AAA was pushing for an examination under oath. As your honors know, an examination under oath is not a judicial process. It is not a process where attorneys can take part actively. I was extremely concerned because my discussions with the Eppersons indicated to me that they needed help and that they did need the assistance of counsel. I then contacted Mr. Berry. We discussed what may or may not happen in the claim. We discussed the Fair Claims Practices Act and the regulations and the reporting requirements. And while I understand they don't have to have a loss adjusted within 30 days, they need to be making some kind of progress. Here, 90 days after the fact, many of the key witnesses that I was able to speak with had never been contacted. We filed the lawsuit. I filed the lawsuit because it seemed to me nothing was happening. I've had a history with AAA. They're very aggressive in their investigations. I wanted to make sure that to the extent we had to act on these people's behalf, we had them in a position where we could do a fee-shifting arrangement if, in fact, we prevailed. The first thing that happened from a litigation standpoint was a motion to stay was filed to allow them to, quote, finish their investigative process. We opposed that. We opposed that with an affidavit from Mr. Berry. We took the position that you can always investigate the claim. We just want to do it with attorney involvement, and we wanted to move forward. Obviously, over my objections, that motion to stay was granted. At that point in time, an individual named Kerry Griggs, attorney here in Phoenix, was brought in, and he was handling the investigation. Mr. Griggs and I, for the next year, worked, and I felt we worked fairly well together in this claim. I've been accused of delaying the claim and not submitting appropriate information and withholding my clients. And I was kind of surprised at that, because going back through the record, and if you look at the affidavits that were attached to the pleading and the correspondence that were attached to the affidavits, a good example, on January 24th, Mr. Griggs of 2014 had requested a bunch of information from me. On January 28th, in one of the documents attached to Mr. Berry's affidavit that he referenced specifically, 4 days later, we provided them with neighbors' names and addresses and phone numbers. We provided them with other neighbors' addresses, witness information. We provided them with information pertaining to a prior water loss, which the company now claims was under investigation. We provided them with photographs, and we provided them with the point restoration documents they had requested. Over the next several months, I provided witness names, an affidavit from a witness. We provided telephone numbers. And every time I got something new, I would pick up the phone and call the old witnesses and say, has anybody from AAA contacted you? And the answer was always, no, we haven't spoken with anybody. Nobody? No, nobody's contacted you. There's correspondence, which I referenced in my briefing to Kerry. And I said, Kerry, it's 5 months since I've been sending you names, addresses, phone numbers. Nobody's talked to these people. What is AAA doing on this case? I never got a response from him.
So, counsel, I'm having a hard time sort of putting this all together. Are you saying that your claim got better after you filed the lawsuit? And your bad faith claim became strengthened because of the actions of Mr. Griggs? If you filed it with 3 months, did you have, at that point in time, a viable claim for bad faith?
At 3 months, I had a viable claim for delay. I had a viable claim for bad faith because necessary witnesses.
But what's the legal claim for delay?
The failure within 3 months to conduct an
Okay, that's a viable, cognizable claim? Delay?
I believe delay is part of an overriding bad faith claim.
It's part of bad faith.
Absolutely.
Okay.
And then you would expect them to be, if they are investigating, and we all realize that one of the primary duties of carriers is to investigate the loss.
Didn't they hire, isn't it true they had Mr. Norwood investigating the claim?
They did have Mr. Norwood investigating the claim, and I'd like to get to him in a minute, but I can address some of his issues now if you'd like.
Sure.
Specifically, the issues I would like to address with Mr. Norwood, and I went back through Mr. Norwood's reports. We're providing names, we're providing addresses, we're providing Chief Borrego's name and number. Mr. Norwood did not contact the neighbor until April of 2014, 5 months after we sent him the information. This is almost 9 months after the fire loss.
You know, counsel, the problem I'm having in getting through the record that we have and the brief that we have is we don't have that information. I don't see on summary judgment where, by way of affidavit or your expert, the plaintiff said AAA should have contacted this witness by name and didn't do so, or delayed X weeks, months in contacting this witness. I don't see that, and instead I see evidence of Norwood contacting a lot of people and submitting reports, but I don't see any analysis of the claims file or anything that would allow us to say, yeah, here is something that the carrier should have done but didn't.
Here's a specific reference that's in the affidavit of Mr. Berry at paragraph 17. It's in the pleadings. Here are letters and documents sent to AAA by the EPPERSON's lawyer, Joe Watkins, as identified in paragraph 4 of this affidavit, show AAA was informed on an ongoing basis of important witnesses and facts relevant to the fire loss of July 16, 2013. But AAA unreasonably delayed its investigation, choosing instead to blame the Eppersons and their lawyer for its no-pay, slow-pay adjustment of this loss. He had taken those letters into account, and he was saying that we had provided them with information, and yet they're still not moving.
Well, I don't see evidence in the record that the. I still don't. I mean, what that supports is the plaintiff's proposition that the plaintiffs put the carrier on notice. Here are some witnesses. Here's how to contact them. Please do so. But I don't see any analysis of what the carrier did in response, other than the broad assertion by Mr. Berry, which I don't place a lot of credence in, that the carrier didn't do it. Well, what didn't the carrier do?
Well, what the carrier didn't do, if you look at the timeline in their own pleadings, is we were sending letters and documents to assist them with the investigation months in advance of when they actually had their investigator follow up. When their investigator did follow up, for instance, he never contacted the fire chief who was solely responsible for making the decisions in this case. We had provided names, addresses, and phone numbers.
So that's an individual that the plaintiffs contend the carrier did not contact, should have but did not.
Absolutely.
And what's that person's name?
His name is Jim Borrego. He was the acting fire chief and the person responsible, according to their own statements and their own investigative notes, for making the decisions on this case. They contacted two firefighters who were present that night, both of whom in their reports said, you need to reference Chief Borrego. We gave them Chief Borrego. They never called Chief Borrego.
Is he the person who left the job and went to
He's still up there. He retired. And I provided the telephone number, name, and address. It's in the correspondence attached to Mr. Berry's pleadings.
Who else should the carrier have contacted but did not?
The carrier should have contacted, when we identified the individuals, the neighbors that we referenced. Ron Atkinson, we gave them that name and address in January of 2014. He was not contacted until April, almost 5 months later. We gave them the name and address of the individual who was checking the gate, a Mr. Haberman. He was not contacted until April. Apparently nothing happened until April, 9 months after the loss, at least on this fire loss. We provided them with individuals who had leased property from these folks. That would be, we also provided them with Gail and Noby, who was the individual who was there the night of the fire. We provided his name and address. He was not contacted until the following April. And in his report, which is in their report, he was very specific. It was an accidental fire. That's the only witness that was there. It took them, again, 9 months post-loss to get a hold of him. We provided them with an individual named Gay Waslow, who had testified regarding her rental agreements with these individuals and the fact that they were not lying, as was accused in the investigation, about having no place to live while they were in Tucson. So we had provided half a dozen witnesses back in January and very early on, and for some reason nobody contacted them. I was pushing and pushing for them to be contacted. Apparently they did contact at least one of those individuals, Atkinson, and they did contact two firefighters. Again, that happened in April. It's part of their report and part of their pleadings. And the one person who was there at the scene of the accident, the night of the accident, testified that it was accidental. We were asleep when the fire started. Again, they have the power, they have the authority, and they have the ability to investigate these things much more quickly. We have clients who are elderly and vulnerable and having a hard time responding. We also provided bank information, records, documents. I couldn't get anything back. And finally, I believe what triggered coverage in this case is, after a long 8-hour rambling examination under oath that made no sense at all, I tracked down Mr. Epperson's doctor. I had been telling Carrie for months, there's something wrong here. And I got a pretty definitive letter from the doctor that this individual suffers from any number of issues, including kidney failure, diabetes, medication, pain medication, and early onset dementia. That happened in late July, and the discussions shortly thereafter led to payment of the claim, confirmed in October, made in November, 14 months, 15 months after the fire loss occurred. Part of the problem I have in this case is kind of proving a negative on what they may or may not have been doing. I believe the court's well aware of the case law on bad faith in Arizona. And if you look at the investigation that was occurring, and I will be honest with you, I would have liked more detail from Mr. Berry and his affidavit on the specifics that we gave him. It was quite a lengthy affidavit, but he did address the fact that we were providing communications, we were working with them, and he felt the delays were unreasonable. Part of what occurred to me, especially preparing this last week for this hearing, you go back through the Norwood reports and the investigation reports, they decided these people were frauds. They were not looking for evidence to pay this claim. They were looking for evidence to deny this claim. And for instance,
what evidence do you have for that?
Well, for instance, they subpoenaed the criminal records of Mr. EPPERSON's son-in-law. They started getting into a dispute that the EPPERSONs had based on the prior water loss which had been paid with Point Restoration Company. And these were red flags, fair enough, but they weren't looking at the white flags. We were giving them to counter the red flags as we went through the investigative process.
I didn't see a reference to the subpoena in the record.
It's in Mr. Norwood's investigative report that the criminal records of the son-in-law were subpoenaed. It happened during that first week in April when he was basically doing all of his follow-up work on this specific case.
I mean, just to be the devil's advocate here, that AAA did have the statement made by Mr. EPPERSON to a neighbor to the effect that he was going to build a house and then burn it down. And didn't have reason to know until very many months later that Mr. EPPERSON was maybe not competent to have made that statement.
I agree with that completely, but the other thing they also had was evidence from the witness who was present the night of the fire that directly contradicted that. They had evidence that could have been obtained if they would have called Chief Borrego. The bottom line is I firmly believe they set out to deny this claim. I believe that coverage coming after 14 months came on the heels of the investigation we did. I litigated this case even though I wasn't in litigation. This was litigation for me. We were responding to discovery. We were making people available, making trips up there, doing the legwork. And one of the things that caught me last night in going through this, and it kind of is in the mindset of AAA, and I'll stop with this and leave a few minutes for rebuttal. There's a note in their brief that when we finally got the medical evidence that this poor guy has all of these issues, well, their only witness can't testify now, and that makes this case even more frivolous. They just are sort of merciless with the way they handle these things. These folks were scared at the beginning of the case. They needed guidance through the case. Technically, if there's a prevailing party in this case, it was us. Now, the other thing that we had that was we never got past the basic depositions. And I'll leave you with one thing that I think is very telling in this case is after the motion was filed, but before the case was gone, I deposed Mark Winbin, the adjuster who, according to him, Mr. Winbin, had all of the authority on this case. And I went through every single piece of document that we provided to Kerry Griggs, every report, every person. This is 2 years after the loss. This individual from AAA had never been provided with these items. And I'll address that a little bit more in rebuttal. Thank you.
Morning, Your Honors. My name is Christopher Robbins. I'm here on behalf of Defendant AAA, AAA Fire and Casualty. Your Honors, I just heard an oral argument in which Mr. Watkins said he is the only witness in this case. He's not a witness. He has no personal knowledge of anything that happened here. His letters are obviously inadmissible hearsay. For all of the reasons we stated in our answering brief, those letters were completely and utterly irrelevant and meaningless. Let me give you an example. He says we didn't talk to a neighbor named Ron Atkinson. Ron Atkinson had nothing to do with the fire loss. In fact, it was Mr. Epperson himself who called 911 and reported the fire loss. He talks about the lessee down in Tucson named Gay Waslow. What she said is she had been leasing a mobile home from the Eppersons, but then because Mr. Epperson had all kinds of health concerns and needed to be in Tucson, she moved out of that and they moved into it. What she did is confirm that Mr. Epperson lied to AAA when he said that his tenant had been evicted and had filed a lawsuit against the Eppersons for wrongful eviction. I will be eternally mystified by what advantage they think they get by showing that Mr. Epperson was mentally incompetent. In other words, he's incompetent to testify. He is their key and generally only witness to any of this.
Well, there was another occupant of the house at the time with Mr.
Right, and that was Annabelle.
Annabelle. When did AAA contact him?
I believe it was after Mr. Epperson's deposition, examination under oath. And let me state this, first of all. Examinations under oath are required by the policy. That's a requirement by the policy, because how can the insurance company find information other than through the principal primary witnesses, who are the insureds? Mr. Watkins was right. It was like an 8-hour examination under oath, at which he was present and was perfectly capable of defending Mr. Epperson in any way he wanted to. Usually you don't need attorneys at examinations under oath because you're just gathering the facts. In this case, this examination under oath created so many wild goose chases and was so contradictory that every 5 minutes Mr. Griggs had to go back and start over again and try to move forward. And okay, now you said this 5 minutes ago, now you're saying something different. It was generally useless and was not cited by either party because there was nothing in it.
What about contacting the fire chief?
The fire chief, Mr. Norwood, did attempt to contact him and was unable to locate him. What Mr. Norwood did do was he contacted most of the other sheriff's deputies and firefighters who were there, and what they told Mr. Norwood is that Chief Borrego said that this was a suspicious fire. All of that, just as like what Mr. Watkins is saying, is hearsay. But that's the information that we had. And the thing is, AAA wanted to get information from the people most knowledgeable, and that was the Eppersons. It was their claim. It was their property. Once the examinations under oath occurred, then Mr. Norwood and Mr. Griggs and the claims adjuster, Mr. Wenban, had the information to pursue an investigation, which is what they did. And so here's the situation. And Judge Brown, you suggested this as well. When you file a lawsuit, you need facts. They offered nothing. In comparison, AAA offered its computer notes, which are, to borrow from Justice Feldman in the Brown versus Superior Court, a blow-by-blow diary of everything that happened in this claim file. It showed everything that AAA was doing to investigate the claims. AAA offered the sheriff's office reports. AAA offered the fire department reports. AAA offered 4 detailed investigative reports from Jim Norwood, who tracked down every person he could, engaged in detailed interviews. He even followed up on the many wild goose chases that Mr. Epperson sent him on. And so when Mr. Watkins says he spoon-fed information to AAA and literally performed the investigation for AAA, that's just demonstratively false. And the beauty of it is, as the trial judge found, it's all in black and white. All the court needs to do is go to AAA's statement of facts, and I think there's like 30 or something exhibits. I always hate to do that, bury a trial judge with all of that. But it's all right there, in black and white. And what do you have on the other side? Nothing. You have hearsay letters from Mr. Watkins. You have no affidavits except for the one that shows from Gay Waslow that shows nothing. And then you have an expert, a so-called bad faith expert who comes in. And one of the things that we really hope that the court will do in this case is do exactly what the trial judge did, find that Mr. Berry's affidavits were completely and utterly worthless. There is no such thing as an insurance bad faith expert. If it's reasonable, the jury can determine whether the insurance company acted reasonably, and an expert is not going to know the state of mind of the claims adjuster. The expert is not going to tell the judge what the law is or how to instruct the jury. And this is a point that we really hope you'll address in your decision. Mr. Berry's affidavit should never ever use the words bad faith.
What's AAA's response to the contention that the adjuster was unaware of all these witnesses, had done nothing with respect to the witnesses that the plaintiff had identified?
Well, first of all, Your Honor, a couple of things. That deposition occurred after we had briefed the motion for summary judgment. It's too late. But more importantly, what he said is not that I never received anything. He says he didn't recall receiving Mr. Watkins' letters in this one claim among the hundreds of claims that he has. He didn't receive those particular letters, but the letters were investigated by his team, including the attorney, Mr. Griggs, and the investigator, Jim Norwood. They were investigated, and what Jim Norwood found out is that every one of those people that Mr. Watkins identified had no relevant information, or in the case of Mr. Enabo, it was just sort of milquetoast information that really didn't establish one way or another about anything, and in fact conflicted with Mr. Epperson on a number of issues. I mean, one of them will testify that they were operating off of a generator. Another one's testifying they're operating off of the power grid. I mean, it's just conflicting evidence. But then the big point, and here's sort of the really big point is, AAA didn't deny the claim. It paid the claim. It paid $165,000 on this claim, bringing the total for 4 claims over a 2.5-year period AAA paid $250,000 on a house and property that the Eppersons could not sell for half of that.
Of course, counsel, that was AAA's decision to insure that property.
Exactly, Your Honor, it was, and that's why AAA followed through on its commitment. It insured the property. In hindsight, that was a very, very poor decision. But it insured the property, and it paid on all of the claims that the Eppersons made. Each time the Eppersons pocketed the money. They didn't do repairs, but that's their right. They have the right to do that. That's not AAA's business. But AAA paid when it was able to complete its investigations, delayed and all through by the Eppersons.
It looks to me from the record that, the fire happened in the summer of 2013.
Exactly.
Mr. Epperson finally sat down for his examination in, help me out here.
Early February.
February of 2014. It wasn't until November, 9 months later, 8 months later, that the claim was paid.
Right.
What about, I see that you're arguing that there was very little that could have been done until after the Epperson interview. What about the delay or the time period between February of 2014 and the decision finally to pay the claim in November? Why could a jury find that delay was in violation of the duty of good faith and fair dealing?
Absolutely not, Your Honor. Mr. Watkins said the Eppersons were frightened. They were frightened because their company, their insurance company, which already had paid them $80,000, was investigating a claim. The investigator was requesting recorded statements, which is how you investigate a claim. That's what you do. They were requested to submit to examinations under oath as required by the policy, and they refused.
But what
It's
about,
only
but after that interview finally took place in
After
February,
that
what about
interview-
the time that elapsed between February and November? Could a
Because-
jury find that was unreasonable?
because absolutely not. Mr. Norwood had to follow up on so many red herrings, so many wild goose chases. He tried to track down people, and these are people scattered over, a rural community. He found out, for example, that Mr. Epperson had once claimed that some solar panels in a generator were stolen. Mr. Norwood tried to find that out, and nobody knew anything about it. He tried to track down Chief Borrego, couldn't find him. He did eventually was able to contact Mr. Annabo, and primarily because it was such an ambivalent interview, AAA said, okay, we will pay. So then what do you do next? Next, you have to send in somebody to prepare an estimate for the damage to the house. And that's what AAA did. As soon as they made the decision to pay, they sent that none had ever been done before. They sent in one of their, it's called a direct repair network, one of their preferred providers. He went in and did a detailed estimate for repairs to the house. And as soon as they got that information, they paid. They paid $165,000, and I think we've shown you photos of the house. And that's after having paid, what did I say, $80,000 or $85,000.
Counsel, could you opine as to why the Superior Court did not address the issue of attorney's fees or deferred the issue of attorney's fees?
I can't, Your Honor, and I didn't even know procedurally, what to do in that situation because I've never seen that before. I don't know.
I'm presuming the request was timely for fees.
We did make a timely request. In fact, ultimately, when we didn't see anything happening on appeal, we submitted an application for attorney's fees. The judge said what he will do is defer an award of attorney's fees until after the appeal's over, which is something I've never seen before. But can you do that or not? I think he can still do that. I'm not sure. This is, but it's one thing we will obviously be pursuing. So, Your Honors, in addition to affirming, we ask that you address two particular issues. One, you don't file a lawsuit, especially a first-party claim, until the claim is fully adjusted. There was never a breach of contract in here. They couldn't even identify a term of the policy that was allegedly breached. The complaint for breach of contract was filed in violation of Rule 11. The only way a company breaches the duty to pay is when it knows what it owes through agreement, arbitration, award, or judgment, and then refuses to pay. That never happened, and it never will happen because AAA paid. As soon as it could determine what was owed, it paid. As far as bad faith, how can you determine whether it was a reasonable investigation, evaluation, and processing of the claim when the insured is holding you up at every step of the way and preventing you from adjusting the claim? Arguably, the complaint filed when it was a breach of the duty of cooperation. This is the time when the parties are supposed to be working together to adjust the claim, and they're filing a complaint alleging that AAA breached the contract, acted in bad faith, and is working with an evil mind toward them. Arguably, that's a breach of the duty of cooperation, avoided the policy, and as I've already mentioned, there should be no such thing as a bad faith, an insurance bad faith expert. Mr. Barry's affidavits, while enlightening about the history of insurance, offered nothing in this case. And him saying 3 or 4 or 5 or 6 times that AAA acted in bad faith is completely meaningless and does not assist the jury whatsoever. Unless the court has any further questions, I'll sit down.
No, thank you.
Thank you, Your Honors.
As the court knows, the duty to investigate a claim and bad faith can be ongoing, both beginning with and throughout the process of the claim. When we have people that need legal help who are not accurate reporters, and we have an insurance company that's taking an aggressive stance, we don't have a lot of other options on my side of the coin other than to initiate litigation so we can at least be part of the discovery process. And in all fairness, we were not only not blocking their efforts, I worked extensively for over a year obtaining information for Mr. Griggs. What are the issues of fact in this case? 2 years after the loss, we took Mr. Winbin's testimony. It's in your briefs. He was the decision maker on this case. Mr. Winbin, in June of the following year, 2015, 2 years later, have you reviewed these letters or seen them before today? Not that I can recall. Do you know if Mr. Griggs passed these letters on to you or as they were provided to him through my office? Apparently he did not, or you can't recall. Is that a fair statement? I don't recall, so I couldn't even begin to say whether Mr. Griggs had sent them to me, and I just don't remember or not. But as you sit here today in June 2015, you do not recall seeing these particular letters before today. No, I don't. This is the individual responsible for making the decisions on this case. I am giving Kerry Griggs information. I am giving him witnesses. My letters are not hearsay because they were incorporated into my expert's report. They are part of the claims handling process. Let's talk about the investigation that Mr. Norwood made. He was investigating the prior losses, true. That's when they were talking about solar panels and things, and they finally paid those claims. We're here on the June 13th claim in July of 2013, the fire loss. Mr. Norwood, and you asked an interesting question here, Your Honor. We gave the EUO in February. In January, before that, we had provided voluminous information, including witnesses' names and addresses. I ultimately got him Jim Borrego's phone number and contact information. It took me 10 minutes to find it. Maybe that's hearsay, maybe not, but it's in the correspondence and it's in my expert's report. Mr. Norwood waited until, April to do anything with that information. And he still never tracked down the most important witness, the fire chief. The reason this claim was paid was because I pushed it on their behalf. This was a claim that was set up to be denied. When we filed the complaint, they were in violation of the Fair Claims Practices Act, or at least portions of it. They hadn't taken the testimony or investigated the key witnesses, and when we provided them to them, they still didn't follow through. It was only after we proved this man had dementia, and only after months had passed since the EUOs, that they finally consented to pay the claim. And as you know, finally paying a claim does not excuse potential bad faith. We're talking summary judgment. There's issues of fact at every step of the way. Was it a legitimate investigation? Was there evidence to support where they were? I think that we're just way premature at summary judgment here. Thank you.
Thank you. Thank you to both sets of lawyers for your argument and your briefing. We'll take the matter under advisement and issue a decision in due course. Now we stand in recess.
Thank you.